As Katie has said, my name is Mairead Knott. I'm a community legal worker with Nipissing Community Legal Clinic. For those that aren't familiar with our services, we are a local legal clinic funded by Legal Aid Ontario. We provide free legal advice to anyone that calls in. We do represent low-income individuals with respect to social assistance matters and housing as well. We also do Canada Pension Plan benefits as well. So what I'm going to do today is I'm going to provide an overview of some of the residential tenancy rights and responsibilities of tenants. I do have time for questions at the end, or I've made time for it within there. And here's the overview of what we're going to go through today. I'm going to try not to read the slides one by one because I know that drives people usually, it's not a pleasant experience sometimes. So if you have questions, I would just ask that you hold them to the end. I can't provide legal advice today on specific legal situations, but I will have the contact information for our clinic so that if there is a specific issue that you want to talk to a lawyer or a legal worker about, you can call in and make an appointment. So we'll start by just talking about the RTA, which is the Residential Tenancies Act, which is the piece of legislation that governs residential tenancies within the province of Ontario. Not everything is covered under the Residential Tenancies Act. Really, your apartment buildings, your residential complex, your standard areas are covered, but you are going to have some exceptions. So exceptions to that include where you share a kitchen or a bathroom with the landlord, the owner, their child, or their spouse. We see this one quite a bit. Seasonal or temporary living accommodations, so cottage rentals or motels, hotels. Nonprofit housing co-ops are not covered by the Residential Tenancies Act, except that in order to evict someone from it, they can apply to the Landlord Tenant Board for the eviction order. But decisions regarding eligibility and whether or not you're compliant with your co-op rules are not under the purview of provincial legislation for the Residential Tenancies Act. Emergency centers, commercial real estate, and business and residential together are not covered. The key with the Residential Tenancies Act and whether or not something is covered is going to be on the specific situation, right? So one of the things that we've noticed is with hotels and motels, it'd be easy to say that you're just not covered if someone identifies as a hotel, but it's going to depend on the terms and conditions of that particular rental agreement. So we usually encourage people to try and get legal advice, even if they don't think they're covered, because there are common law provisions that apply. So I've just sort of gone with that. One of the things is with shared rental housing. So when you're living with someone else, if your roommates are covered, if you have a head tenant, so a head tenant would be the person that primarily rents the unit, and then perhaps they rent out a room to a friend or someone else. That head tenant is covered, and the individual tenants. Not covered are commercial tenants and licensees. So under the Residential Tenancies Act, there are a number of rights that are sort of inherent within that legislation. So your landlord you have a right to be free from harassment, to have your unit in a good fit state of repair. You cannot increase the rent anytime, and you have the right to quiet enjoyment of your unit. These things, if any of these rights are violated, that could be a subject of an application to the Landlord and Tenant Board. So sidebar as well is that in Ontario, the Human Rights Code generally trumps any piece of legislation. And most legislation has a provisional clause that says this legislation trumps everything unless it's the Human Rights Code, and that goes there. Where we see this a lot is the landlords have a duty to accommodate people to the point of undue hardship. So often with our clients, when they have mental health issues or they have maybe children with mental health issues that are causing disturbances in the unit, there's an onus of accommodation that falls onto the landlord. And with accommodation, there's two parts to it. There's substantial and procedural. Substantial is the actual reality of the accommodation. So I always say, you know, if someone is in a wheelchair and they need a ramp, the building of the ramp is the substantial accommodation. Procedure is looking into it. Often what we run into is landlords right away saying, well, I can't do it. And unfortunately, that's not good enough. You have to go through the process of investigating how you can accommodate this person. What we often tell tenants, though, too, is that accommodation is a two-way street. When claims are heard before the Human Rights Tribunal, or this is issued before the Landlord-Tenant Board, they are going to be looking that both parties are willing to find an accommodation that works for both of them. These cases can be really complicated. So we always suggest that if there's potentially a disability that is resulting in some of the issues in your residential housing, that you seek legal advice on that as soon as possible. So, and it's not in my slide deck, but one thing I wanted to talk about too is there's a difference between when someone is a tenant versus a prospective tenant. So landlords with prospective tenants can request things like credit references, rental history information, and income information. You cannot refuse to rent to someone because they're on social assistance. But if you feel that they can't make the monthly payments based on this information, you can refuse to rent. So that's a slightly tricky area, and it's very nuanced. The offenses under the Act are very clear: harassment, preventing a tenant from accessing their rights under the Act, or for tenants from organizing. Those are all prohibited. So a few things to go over the landlord responsibilities, which always sort of counter what the tenant's rights are. So it fits together. The unit has to be fit for habitation, in a good state of repair, and the landlord has to ensure they're compliant with health and maintenance standards. This applies even if the tenant moved into the unit knowing that like there was a big hole in the wall. That doesn't mean the landlord doesn't have to repair it, and it does not mean that that does not have to be addressed. There's a few things your landlord cannot do as well. Substantially interfere with the tenant's reasonable enjoyment of the unit, harass, coerce, threaten, or interfere with the tenant, change the locks without providing the tenant to key, illegally enter the unit, or interfere with the supply of any vital service. So cut off the hydro, cut off the gas, any of those things are prohibited. Substantial interference can go with the landlord's own behavior towards a tenant, and it also can be for failing to address the tenant's concerns regarding other tenants or issues within their tenancy. With respect to entry of the unit, and we do get a lot of questions, there are times when the landlord can enter the unit. They do not need the consent of the tenant. As long as they provide 24 hours written notice and they're coming in to do repairs or an inspection of the unit, the tenant has to let them in. They have to come in between 8 a.m. and 8 p.m. And if a tenant refuses to let them in without really a valid reason, that could be considered substantial interference by the landlord. So one thing we always try to encourage our tenants to do is communicate openly and act reasonably with their landlords as well. And we would expect landlords to do the same. The exceptions to the 24-hour notice rule is if there's an emergency, or if a tenant has said that they're moving out and they need to show the unit to other prospective tenants. So there's some rules relating to rent. We get a lot of questions on this as well. A last month's rent deposit is permitted, but it can only be claimed he can only claim it for a new tenant. So if a tenant moves in and they don't pay a first and last month's rent, the landlord cannot then expect them to pay it 6 months down the line. If they want to, they're more than welcome to, but there's no enforcement or anything that can be done if they don't pay it. You can't require post-dated texts or an automatic debiting of the account. If a tenant and a landlord agree to these things, that's different, but a landlord cannot unilaterally impose that requirement or restriction. Rent can only be increased once every 12 months. Now, currently there is a rent freeze due to COVID. So notices of rent increase cannot be issued by landlords during the year of 2021. Whether or not that's going to be extended, we don't know, but currently that is in place. Landlords must also provide rent receipts free of charge once a tenant asks. And when rent increases are permitted again, the way the Act works is it has to be with 90 days notice. The notice has to be specific for the last day of the rental period. So it can't take effect on the end of the month. It has to take effect on the first day of the month. And it can only be by the guideline amount that the province announces every year. Usually it's a cost of living, like might be 2.1, 1.2, but the rent increase cannot be more than that. If a landlord wants more than the standard rent increase, there's a separate application they can file to the Landlord Tenant Board, and that's called an above the guideline rent increase. That is for things such as capital repairs or major upgrades, and requires a lot of documentation on the landlord's part. Those generally will go to a written hearing, so a tenant would receive notice of an above the guideline rent increase, and they would have an opportunity to put in writing any objections they may have to that. Rent deposit rules continued. The last month's rent cannot be applied to anything other than the last month's rent of when you live there. Often we've seen landlords try to apply it to arrears or outstanding expenses, and that is not permitted. As I've tried to emphasize quite a bit, tenants and landlords can reach an alternative agreement. We sometimes have tenants that say, I want him to apply the last month's rent to my arrears so that I don't owe any money, and that's fine. That's their agreement, but they need to understand that that's got to be an agreement. It is not a decision the landlord can make on their own. And it's not a decision the tenant can make on their own. It has to be an agreement. The rent deposit has to be returned if the landlord does not provide vacant possession to the tenant. However, if the tenant pays a deposit and then changes their mind that they don't rent the unit, they do not necessarily get that money back. Key deposits are permitted, can't be more than the cost of the key, but things such as damage deposits or other requirements from a landlord are not legal. The only thing permitted in the Act is the last month's rent deposit. Interest has to be paid at a rate equal to what the guideline interest increases every year. So if it's 2.1%, then for that year, 2.1% interest must be paid to the tenant. That can be paid out towards the end of the tenancy. Sometimes it can be used to offset rent 1 month. You know, each landlord and tenant have a different arrangement, but they are entitled to interest on that deposit. Repairs and maintenance, as we've talked about the landlord, oh, I skipped a slide there, but anyway, I'll tell you about that. Any requests for repairs and maintenance really need to be in writing. If a landlord will not complete repairs and maintenance, and this is one of the most common questions we get here, and one thing I've noticed is that we all communicate by text these days, or most things are by text. I discourage that where possible, only because with a text, we're usually a lot less formal in our language, and we're not clear. When you go to the Landlord Tenant Board, if a landlord has not repaired something, they're looking for evidence that the landlord was aware of the repair issue, that you notified them, and that they didn't respond. So even if it's an email, but something dated, clearly stating what needs to be done, I try to say, stay away from emotional tone and language, because it all becomes evidence, right? And when it comes to evidence, you always want to be the more reasonable party. A lot of the times there's a lot of conversations about things, and I encourage tenants, if there was a conversation, reiterate that conversation in your request. You know, like, further to our conversation yesterday, I let you know that the window is broken. You said you would get to it Tuesday. It's not done yet. You want to make sure that you're doing those things. If the landlord fails to comply with any of their responsibilities, you can apply to the Landlord Tenant Board at any time. The key is that once you file your application, you can only be compensated, and they can only consider issues going back 1 year from the date you filed your application. So there is a bit of a clock that runs on it. So the sooner, the better for filing. Even if you're not living in the unit anymore, same thing, you can go back up to 1 year. So often what we'll see sometimes is tenants will move out and then feel comfortable filing an application because they didn't want to deal with any more, especially with issues with harassment and substantial interference. They didn't feel comfortable filing that application while they were still living in the rental unit. So that's the one half of it. The second half that impacts a lot of our clients or people in the community are eviction. And there's a little bit of misinformation about that out right now. And we're finding that especially with COVID, things are a little bit confusing. As we now know, there's a stay-at-home order that has been issued. And once again, they've issued a moratorium on enforcement of eviction. Where that gets confusing for people is that while the sheriff will not change locks right now with an eviction order, the landlord-tenant board is still fully up and running, and they're still hearing cases. So they will still order eviction. It just cannot be enforced at this point in time. So for any clients or community members, if you get a notice of eviction or you get a notice of hearing, it's important to make sure you're attending the hearing, you're seeking legal advice, because your tenancy can still be terminated during this pandemic. It just may not be that someone will change the locks just yet. So you don't want to find yourself in a situation unexpectedly. Another development that happened late last year is that it used to be that before the sheriff changed the locks, they would come and post a notice on the door of the unit and tell you the exact date and time they were to come back and change the locks. Those notices are now mailed out. And so we do get clients looking for something on the door, but they don't do that anymore. It comes through the mail. So it's important to constantly check our mail. I think that especially, probably dating myself, but especially now with the internet and email, we do everything online. That tends to be our default for where we go for things, but there are still some procedures like the sheriff's that do follow the mail trail. So it's important to encourage our clients to check their mail on a regular basis, especially if they're concerned there could be something coming from the landlord or something's not going well. So any eviction has to follow the requirements of the Residential Tenancy Act. There are what we call fault and no fault evictions. No eviction can occur without an order from the board being issued. So you have to go through the landlord-tenant board to get an eviction order. There's no way out of that process. And once an eviction order, even with an eviction order is granted, it is the sheriff that has the authority to change the locks, not the landlord. So the landlord has to go pay the sheriff will mail that notice, they'll come back at a specific date and time, and then they will change the locks. Eviction for fault, there's a number of reasons, right? It can be that you haven't paid your rent. The landlord is alleging that you've caused a safety issue, you're interfering with reasonable enjoyment, illegal act. For subsidized housing, it could be that you're misrepresenting your income, overcrowding, or damage to the unit. These evictions can occur anytime. Certain evictions only can occur at the end of the rental period. So if you have a lease agreement, the termination date on any notice has to be for the end of that lease. For fault evictions, the only one that falls under the end of term eviction is if you're persistently late paying your rent. That one would be, they could give you a notice for that, but the notice has to be for the end of the lease. So no fault eviction is where the tenant hasn't allegedly done anything wrong, but the landlord has a right to reoccupy the unit. So really what we see is landlord's own use. They want to move in, they want their child to move in, or they've sold the unit and the person who's bought the building wants to move in. They need to completely gut the unit because there's repairs and work that needs to be done, or they're converting the unit to another use, either a condominium or maybe commercial use. For these, same thing, eviction has to be at the end of term, and generally the notice periods are a little bit longer. Some notices are voidable, which means that if you comply with what the notice is asking you to do, it's done and your tenancy is safe. Those ones you have to do it by a certain date, and it's important that if you did void the notice in any way, shape, or form, you keep evidence to that effect. So one of them is rent. When you are behind in your rent, the first thing the landlord has to give you is what's called an N4 for non-payment, and that gives you 14 days to pay the money that you owe. If you pay the money in the 14 days, you're fine. If not, after that, on the 15th day, the landlord can apply to the landlord-tenant board. And again, there would be a hearing, you would receive a notice of hearing, and you would have an opportunity to either dispute or ask for time to pay. Misbehavior, overcrowding, same sort of thing. These are N5 notices for cause. So the way these notices work is that the first notice will identify what the issue is, what the behavior is. Say it's loud music being played all hours. You would have 7 days to correct that. So as long as you don't do it again within 7 days or you change your behavior, then that notice is void and the landlord cannot apply for eviction on it. If you don't remedy it within the 7 days, they can apply for eviction. With these, even if you remedy it within the 7 days, but within the 6 months, there's another incident, Doesn't have to be the same incident, doesn't have to be music again. It could be you got in a fight with your neighbor. That would be a second notice your landlord would give you, and that cannot be voided. That the landlord would then be able to proceed straight to the board to apply for eviction. Some of them are not voidable. So same with persistent late payment, landlord's own use, demolition, conversion, illegal act, or business. So really it's only substantial interference and arrears of rent that are voidable notices. If you receive any other type of notice, chances are your landlord is going to be applying to the board for eviction. We really encourage people to contact a legal clinic as soon as they get the notice. Notices are very specific, and divisional court has really hammered down that some things can be amended, notices cannot be amended. So often there will be a fatal flaw that will result in a dismissal if the date's wrong, if the details aren't there. So in the legal clinic, we like to see the notices as soon as possible because we may be able to salvage something before it even goes to the landlord-tenant board. With the no-fault notices, these are changes that have occurred in the past couple of years when there were some significant amendments to the Residential Tenancies Act, now requiring compensation to be paid to tenants. So if a landlord has served a notice of, I want to move into the rental unit, and we do receive a lot of concerns over landlords may be using this as a way to get a tenant out that they don't like, that maybe it's in bad faith, it's not legit. The new requirements are that they do have to pay compensation to the tenant. If it's a unit, a building with under 5 units, they have to compensate the tenant 1 month's rent. If it's over 5 units, it's 3 months rent. Or they can offer another unit that is acceptable to the tenant, and a landlord must also live in that unit for 1 year. So if you're in a building, and we don't see this very much in high-rise buildings, you'd see it mostly in smaller buildings, they can either pay the compensation or they can say, I want to live in this unit, but I have this other unit available for you over here. Same with demolition, conversions, and repairs. Demolition, conversion, and repair, the key with this is that they have to give the tenant the right to reoccupy the unit once the work is done. It's not always realistic for tenants to leave and then come back, but some do have family members that they can stay with. So when it is, they're demolishing the unit, they're major renovations, someone can't stay there, they have to compensate them in terms of that 1 month's rent or 3 months, and they have to give them the right to reoccupy the unit. It's also important that the tenant communicate to the landlord that they intend to move back in once the repairs are completed. So when a landlord wants to evict a tenant, there's a few things you need to always be looking for and I talked a bit about this, it always starts with a notice of termination. There's no way you can go straight to the board without some former notice of termination. Move out and the tenant hasn't moved, the landlord could apply for what's called an ex parte order saying, you know, he signed an agreement to move, they didn't move out, I want possession. But again, the notices are so important. It's also important for tenants to realize that a notice is just a notice. They do not have to move out by the date in a termination notice. It just means that after that, the landlord can apply to the landlord-tenant board to have them evicted, but they would have a hearing and they'd have an opportunity. Often tenants see that and they don't understand that this is the first step in the process. If you do have tenants, or if you are a tenant and you actually do want to terminate your tenancy, you don't want to stay there, there are things that you can do. You can provide a notice to end the tenancy, which is an N9. I should note that all these for landlord-tenant board website as well, so you can access all of them. We do always have hard copies at the clinic as well, and we can easily print them out for people if they need them. Any notice of tenancy, termination of tenancy, has to be 60 days notice. It's with the exception of a lease. A lease agreement is a little bit different. I'll talk about assignment and subletting in a minute. The other thing is if you want to move out earlier than the required notice period, you and the landlord agree that you're going to move out on a certain date. The other things as well is this was an amendment a few years ago as well, is that when there's an issue of domestic violence and abuse, there are different rules in place for terminating the tenancy that are designed to make it easier for a victim to simply leave and move on and protect their safety. If you're at the end of a lease and you have the option, or you're before the end of a lease, and you can also apply to the board to terminate your tenancy. Back in the day, I would have said that's a great option. Right now, the landlord-tenant board is very behind in the hearings. They've had a backlog even before the shutdown from COVID. So the reality is that tenant applications do not get heard quickly. So if it's an urgent matter, going through the landlord-tenant board for your tenant rights, it's not really advisable right now. I mean, I still think you should do it. It's just, it's not going to get you a quick remedy. So if it's an urgent situation, you might want to consider your options while you're doing that. So with sexual or domestic abuse or violence, the way the Act reads now is that if this is a situation while someone has to leave, or they believe themselves or a child may be harmed if they don't leave the unit, they simply have to provide 28 days notice. There's no timeline. It doesn't have to be at the end of the lease or at the end of a month. They can give that notice anytime. The forms for doing so are, there's also a requirement that the tenant submit a declaration that this is the reason they're leaving the unit. However, that declaration is, there are no details. It simply is a form that you sign saying, I believe that I am not safe here, I am a victim of violence, and that's it. The landlord has to keep the notice and all other documents confidential. They can't share it. And that this information, again, it's very minimal information that people are expected to provide. And I know that's a concern with, you know, victims of violence and sexual abuse and domestic abuse, is this information. They don't have to provide a forwarding address. They don't have to provide any details of what happened. They're simply invoking this clause in the legislation. Again, it's all available on the website. We can always provide advice and guidance on it, but this is one process that has been designed to make sure that it's as simple as possible for someone to invoke that clause when they need to. Subletting versus assignment. So as I said before, the standard notice for terminating a tenancy on a month-to-month rental is 60 days notice, end of term. So when you're not on a lease, you just have to give 60 days. Where people sometimes misunderstand that is it has to be for end of term. So if you pay your rent on the first of the month, your termination date will be on the last day of a month. If you mistakenly put it on the middle of the month or the third of the month, then that notice is not void, right? Like it's not, it won't work. And a landlord technically could come after you if they are unable to rent the unit during that time. If you still have a lease and you want out before the end of the lease, you have a few options, right? Now, the landlord cannot simply withhold consent to an assignment or a sublet. They can't say, no, you're not allowed to do that. You are allowed to do that. With a sublet, the difference is that the tenant is vacating the unit, and really they're renting their unit to someone else, but they are still ultimately responsible. So if the person they sublet it to does not pay the rent or causes problems, they are financially and legally responsible for that. So generally it has a start date and an after date. And also if you're subletting, you have the right to go back into the unit after. Often we see this with student housing. When people are going home for the summer, they might sublet their unit for about 4 months or 3 months until they want to come back. Assignment is different because assignment is you're having someone take over the lease entirely. So when someone's taking over the lease, you're out of it. Your name comes off of it, their name goes onto it, and that all your interest in the tenancy is to another person. You don't have any right to come back to the unit after, but it also means that if the rent isn't paid or there are damages, you're not liable. That's done for you. What happens is if someone simply vacates before the end of their lease, they potentially could be financially responsible if the landlord is unable to re-rent the unit. The landlord is obligated to mitigate their losses, which is try someone else. But if not, the lease is a legally binding contract that says I will pay rent for a period of 12 months. So if any time during those 12 months, on the hook. We see this a lot when it comes to student housing, right? Perhaps renting a lease from a year and then halfway through the year needing to go home. So we just encourage people to try and get advice beforehand and really think about a lease before you sign it and understand that if you need to get out of it for whatever reason, you need to think about it and it may not be that simple, and simply leaving doesn't negate any of your obligations from a legal perspective. So there are other legislation that can affect a tenancy. Earlier on, we talked about the exemptions, things that are not covered under the Residential Tenancies Act. What we often run into in those cases is we will see where you're renting a room from a friend or you're sharing a kitchen or a bathroom with the landlord. The risk with those tenancies is there's no statutory requirement or notice for an eviction process. The courts would hold that you have to be reasonable, but really what we find is there's nothing to stop someone from kicking you out. In those cases, a number of parties usually end up getting the police involved, which never really ends up well, but it's just something to consider, right? Is that when you rent in that situation, you don't have a security or a right of housing. Housing Services Act. So this is our subsidized housing. Where the Landlord Tenant Board can order evictions under the social housing, like under the Housing Services Act, but they cannot make any determinations about subsidy. So they will not, and often we'll see this on an arrears application, they will not say the arrears are incorrect because your subsidy should be reinstated. They won't do that. You have to deal directly with your housing provider and their review process to get that done. If you cannot resolve that through a review process, then that immediately goes to a judicial review, which is a higher court. So often, we really encourage tenants in social housing that the best thing you can do with your landlords to protect your tenancy is communicate with them when there's changes in circumstances or something has happened, or if you've gotten your annual request for documentations and information and you don't think you can provide some of that information because it's going to be late, open a dialogue. Start before you even end up with a notice or you even end up at the Landlord Tenant Board. Once something goes to the Landlord Tenant Board, then tenants become responsible for the landlord's cost of filing, which is another financial burden on them. So the earlier you can resolve something, the better. Here at the legal clinic, we work well with our local housing providers and can assist and negotiate as necessary, but communication is key, especially with social housing. Human Rights Code, which we talked a little bit about, was the accommodation to the point of undue hardships. Just making sure that you're, again, same thing, communicating with your landlord. When it comes to disability information, landlords can't request that. However, it is prudent that if there's a reason there's a behavioral issue or there's some issue happening that may be tied to a disability, even just sort of getting help when you can. There's the Human Rights Legal Support Center, which is a clinic in Ontario that is specifically funded to address human rights issues. They are experts in this area. And again, there's no cost for their services. So we encourage tenants to contact them as well. Before you rent, usually we like to encourage tenants to think about it. Now, I know that right now, the other thing that's going on right now is that with COVID, stock is hard. People are not comfortable necessarily viewing different apartments. There's a lot of anxiety out there right now, which I think impacts a lot of these things. So a lot of this advice may be a little post-COVID, but it's always good to consider that when you're out checking a unit, I never recommend renting unless you've had a chance to see the unit. We live in the world of Kijiji and it's not even Craigslist anymore. But if you can get out and see the unit, it's really important that you do so you know what you're doing. You want to check out the closets, you want to turn the taps on, you want to make sure the water is running, the toilet's flush, that your windows open and close, are there locks on the doors, any outstanding work orders. Now you can get that from the city, that takes a little bit of time. And then things like, does the act apply? Will you be sharing a bathroom with a kitchen, sharing a kitchen or a bathroom with the landlord? Is it a rooming house situation? What's included in the rent? Often there will be misunderstandings between parties because they don't discuss these matters. You know, do you have to pay your own hydro and water and heat? Is there a parking spot? What about garage? Are there common areas that you share with other tenants? Is there a lease or is there not a lease? The Landlord Tenant Board now has issued a standard lease that landlords are supposed to use. Once you sign a lease, you're bound by it, right? So it really is important to be aware of what's in that lease. And usually that's where you'll find things like heat, water, hydro included in there. So you could have a verbal agreement with a landlord. They say, oh, no, it's all included. But if you sign a lease document that says that stuff's not included, then it's not included. So it's really important to rely on the written as opposed to just the verbal. Now, if you don't have a lease agreement, you're automatically a month-to-month tenant. And once a lease expires, then you're automatically a month-to-month tenant. A landlord cannot kick you out just because the lease is over. That's not how it works. The rent, make sure you know how much it is, when it's due, and something not always easy to do, but is it affordable? You know, are you going to be able to maintain this? Generally, the rule is no more than 30% of your income to your monthly rent. That's not feasible for a lot of our clients. The rental market is quite high right now. There's not a lot of vacancy, so it's tough. But it's important to kind of think about it in terms of what is affordable to you. Are there any deposits due? Key deposit, last month's rent, and the move-on date. When do you think you're moving in? And make sure you and the landlord are both on the same date. If they're letting you move in early, are they charging you for that? Are they not charging you for that? So you want to make sure you're considering these factors before you rent the unit. So I think that it's an overview of everything, but there's some information and resources we've provided as well. Like I said, ACTO Ontario is the Advocacy Centre for Tenants Ontario. They're another legal aid clinic that is focused solely on residential tenancies within Ontario. They do a lot of our higher level advocacy work, legal challenges, develop tip sheets and materials. Currently right now, they have some really good tip sheets on video conference hearings, what you need to do, how you can prepare and what to look out for. I can share those to any organizations that would be interested in that. Your Legal Rights Ontario, it's just some easy to find legal legal topics. Same with the Center for Equality Rights and Accommodation. Got some good information on there. As I mentioned, the Human Rights Legal Support Center, we've got their website information up there. We also have CLEO, which is our Community Legal Education Ontario. So they've, you may be familiar with them, but they produce a lot of our materials in terms of pamphlets and informational resources. They have some really good question and answer sections on their website that are geared towards they're not written in legalese, so anybody can read them. I find them quite helpful, and it's a really quick overview if you want some information on the fly. We do have the Landlord Tenant Board. They've got the notices, applications, and information. They've really guidelines on how to fill out these forms. And same with equalityrights.org. Within the city of North Bay, we do have the Community Homeless Chippy, right? So they can provide households experience homeless at risk with direct benefit supports. They have different criteria. Now, as well, you may have read in the newspaper, they really are advocating hard to sort of come up with a rent forgiveness program in association with our landlords, local landlords association, which a lot of people that work in housing are very supportive of, just from the basis that our experience is that a lot of tenants have fallen behind with the pandemic due to loss of income for whatever reason, being forced to make tough choices between, do I pay my child support? Do I pay my rent? So I think any sort of assistance, these are good places to start. If you're on social assistance or your clients are on social assistance, they need to go through their worker to make the referral. If you're not on social assistance, the number is there. They often will work with, if you have Indigenous clientele as well, Suswin will often work with them to partner, and they do have some programs available there to help with rent arrears. Rental Housing Enforcement Unit. This is operated through the Landlord Tenant Board. It's free, but often we refer tenants there as a quick way to deal with, my landlord has changed my locks, they have cut the heat off, they're not doing repairs, if there's any violation of their rights. As I mentioned, with the applications to the Landlord Tenant Board, they are great in terms of compensation and making sure your issue is addressed. But the reality is that right now, that is not the quickest way to get your concerns addressed. So the Housing Enforcement Unit is one way to do it. Also contacting, especially for repairs, City of North Bay Property Standards Office. We really push this for a number of reasons. One, they have authority. They can order that repairs be completed. They can actually go in and do the repairs themselves and slap it on a tax bill on the property taxes. So they have a lot more authority to get these things done. The second part of it is that you can access those reports through a Freedom of Information request. And so if you do need to take legal action against your landlord later on for some of these things, then this is great evidence. You've got an objective third party confirming what the information is. So and it's free. There's no harm, no foul, but I think it's a great way to go about getting your issues addressed, as opposed to waiting for the bureaucratic process to work its way through. And then our information is down there as well. I missed a parentheses around our 7, but that's our phone number. We are currently in the office. Our office is open 8:30 to 4:30. We are not seeing people in person, but we are available by appointment. When clients do have hearings that we're representing on, we are hosting here, recognizing that access to technology is an issue for a lot of our clients going forward. I just can speak provincially as well. The clinic system, we have ACTO, we have a lot of specialty clinics that do that centralized advocacy for us. So they are really pushing the provincial government to recognize that this concept of virtual hearings, while important for the short term, is not always providing our clients with the best access to justice. Ensuring that their voices are heard in a way in these matters, these social assistance matters and landlord-tenant matters, where they are most vulnerable in terms of securing income and housing. So that's my overview. I don't know if anyone has any questions or any further information requests.
Okay, so we have a question here. Are municipalities allowed to impose their own requirements or restrictions on landlords or tenants?
They can. They would have to have a bylaw and they would have to have a licensing scheme. Some municipalities have proceeded with licensing landlords. Tenants, they would not have any authority of. Where that when municipalities will have property standards. They don't have to have a property standards bylaw, but they can choose to have one. And they may have requirements such as limitations on animals, noise bylaws, and hours. That would, it's weird, it wouldn't directly, they wouldn't say you're not allowed to do, like they wouldn't enforce against a tenant other than through a ticket or a citation. They couldn't evict anyone, but if you are knowingly violating, if your tenant is in violation of some housing or of substantial interference by the landlord, if that makes sense, like they kind of go partnering together. But each municipality is different, so depending on your community, it's important to touch base with the municipality if you're wondering. For example, I can say, like, I used to work in Callander and they had no bylaws on cats or dogs limitations, but when I was down in Hamilton, they had limitations on that. So it's really going to differ by community.
I know that that's a question that we've assisted clients with over the years, is whether they're allowed to have cats and dogs in their units, or because there's some ads that you'll see on Kijiji that say no animals allowed.
Well, and that's a slippy, that's a prospective tenant versus a tenant, right? So a prospective tenant, a landlord can technically refuse to rent to them for having an animal because they're not covered by the Residential Tenancies Act yet. But once you pay a deposit and you move in there, you cannot be evicted for having a pet. Even if the lease says no pets, that provision is void. The only way you can be evicted for having a pet is if there's some issues with that. Either it's barking, you're not cleaning up out of it, then you'd be, and that notice would serve. You'd get that, right? Because we do run into that where landlords won't rent to someone if they have a pet, but once you're in, they really can't do anything about it. But one thing I would consider before you do that is that once a relationship breaks down between a landlord, I see a situation where they're trying to get you out all the time because it's exhausting, it's emotionally, it's a hard situation to live in. So I really encourage like communication, trying to keep your relationship good with your landlord and trying to work together where possible.
Okay, so we have another question here. It says, what if they're a service animal?
Well, in that case, refusing to rent, and I think you're talking about refusing to rent in the first place if it's a service animal, right? That would be probably a human rights complaint. I would recommend contacting the Human Rights Legal Support Center and to see whether or not, the only key with that, and they'd be able to advise you on it better, is being able to prove that they weren't renting you because it's a service animal. right, that would be the only exception, is that you would say, you know, you're failing to accommodate, like you're discriminating by not renting to me based on my disability because my disability requires the use of a service animal.
If anybody else has any questions, you can also feel free to unmute yourself if it's easier to ask. I don't
The other thing too is that, like I said, we are in the office, so if anyone wants just to call us, that's okay too.
Perfect. Oh,
we often do have community organizations call because they have a client. So,
I just had a question here. Are you going to share this presentation with people who have signed up? So yes, I will provide a copy of this presentation to anybody who's interested. So I will probably do that afterwards. I'll just send out an email to everyone who signed up today. So we have a comment here. Great, thank you so much. Great information.
yeah, like I said, and if anybody hears from other community organizations, we're always happy to, you know, when our world opens up again, perhaps participate in any community organization.
Thank you so much for joining us today. This is really
someday.
Thank you so much for joining us today. This was incredibly helpful.
Oh, great. And like I said, clients are welcome to call us. We often have other community workers from community organizations that, you know, they might have a client and they don't know how to proceed, what they should be doing with them, and they're welcome to call us as well.
Perfect. And I might be in touch with you again.
Yeah, that's fine.
I really appreciate your time with us today. And yeah, and if you have any further questions, you can also contact me, and I'll put my email address in the chat here. So we will have resources available on our website, and I have recorded this presentation, so I will make it available to anybody who's interested. And I guess if there's no further questions, I will let everyone go for the day. So thanks so much for joining us again, and we look forward to the next presentation. Thank you for your time today. I really appreciate it.
Okay, take care.
Take care. Have a good day.
You too.